So a really common misconception is that you have to be still employed to make or continue receiving work cover compensation. You don't have to still be employed even if you have left the company. However, there is a time frame. Within Queensland, it is usually a period of 6 months from the date of when the injury or illness was documented to your GP, for example. This is reported by WorkSafe Queensland, and according to iCare in New South Wales, there is a 6-month time frame, again from date of injury or illness when this was documented, and possible extension for up to 3 years with more serious permanent impairment. The same goes for Queensland as well. But again, within that 6-month time frame, you are more likely to have a claim approved within a 6-month time frame, and anything beyond that is going to need even more evidence, even more potential witness statements, and it's going to be a much more difficult case to pursue. Your eligibility solely depends on whether you were a worker at the time when the injury or illness came about, and you lodge this claim within that 6-month time frame, ideally. So you could have already resigned, you could have been terminated, or the business could have potentially ceased trading as well. First things first is you need to go to your GP and get the proper medical certificate, which documents your injury, your illness, and your GP will submit that on behalf of you to WorkCover. It will be a Queensland Workers' Compensation Capacity Certificate, or in New South Wales or Victoria, for example, it will be very similar, a certificate of your capacity. Your GP will lodge the claim with the scheme or the insurer. So when I say scheme or insurer, I mean it would be with WorkCover, even be with ComCare. WorkCover is under the state and territory schemes in Australia. It covers employees of most private sector employers and state public employers, again depending on the state or territory. For example, Queensland's compensation scheme is under WorkCover Queensland. New South Wales compensation scheme is under iCare, which stands for Insurance and Care New South Wales. This is regulated by the State Insurance Regulatory Authority. It's short for SIRA, S-I-R-A. Victoria is covered by WorkSafe Victoria. South Australia is Return to Work South Australia, or Return to Work SA. Western Australia's compensation scheme is WorkCover WA. Tasmania is covered under WorkSafe Tasmania. Australian Capital Territory is covered by WorkSafe ACT. It's important to note here that WA, ACT, and Tasmania have these regulators, so the WorkSafe regulators. However, they have additional private insurers who manage these claims. To explain all of these different state and territory schemes regarding the funding and how it actually all works is that the employers in the state or territory pay a premium to WorkCover or a private approved insurer. All of these bodies of authority primarily focus on supporting the local and state workplaces. So again, this covers injuries, illnesses, medical expenses, and lost wages. There is a difference between workers' compensation and employment law. Workers' compensation is related to the illnesses and the injuries, whereas employment law is related to pay issues, unfair dismissal, these kinds of issues. So they're two separate bodies of authority. So that is the WorkCover side. Now, the ComCare side, which is something that is personally new to me, that I've had to do some research on and actually kind of look up what are the key differences between the two, because I personally have not gone through ComCare, which is a Commonwealth scheme, cover the employees of the Australian Commonwealth Government. So these are large corporations in Australia that are licensed to actually self-insure under ComCare. This is going to be really big corporations such as Telstra, Australia Post, and usually the big four banks like NAB and Westpac, these types of large corporations. Comcare is a federal authority. What happens with disputes and appeals under Comcare, for example, is that the initial reviews are handled internally first by Comcare or the insurer. If you still disagree with the outcome after the internal review with Comcare, you can actually take your case to the AAT, which stands for the Administrative Appeals Tribunal. The AAT is an independent body which is separate from Comcare. Look at all of your evidence and make its own separate decision. So firstly, Comcare is your first point of contact. Any appeals after that will go to the AAT. And then your case would start from there, for example, if it's approved. You can still submit a Comcare workers' compensation claim even if you've already left the company or the government agency. This is indeed where the injury or the illness occurred. You just have to lodge within the time limits, and remember, 6 months is going to give you a far higher chance of your claim being approved. So you would go to your GP, you would get the Comcare certificate, and again, they would process that on your behalf, confirming that your condition, your illness, your injury is indeed work-related. If approved, Comcare will pay you compensation, medical costs, weekly benefits, lump sums. Again, depending on your case, depending on your injury, your illness, this is going to be different for everybody. I wanted to share this misconception because what happens usually is that someone is severely bullied, sexually assaulted, harassed within the workplace. Their body can't take the stress, they can't face going to the workplace anymore or being around the people that are bullying, harassing, whatever the situation, and they quit, they resign, and they leave because they just don't have the emotional capacity to deal with it, and they need to step away immediately. This is for those people that are still left with an injury or an illness. Perhaps maybe within 2 to 3 months you now feel ready to go and submit a claim because you are still being impacted by this incident, by this event. You are entitled to do so.